This is the case with section 31b2 because it provides for compulsory licenses in respect of works for the benefit of the differently abled. Persons working for their benefit on a profit basis can apply for compulsory licenses to publish the work, and there aren't too many preconditions attached to the exercise of this provision as well. The applicant has to first serve the copyright owner or the publisher with a copy of the application, and once the board is satisfied with the credentials and good faith conduct of the applicant, it can grant such licenses expeditiously. The license only has to specify the means and format of publication, the period during which the license may be exercised, and the number of copies that may be issued, including the rate or royalty payable to the copyright owner. So this fairly simple provision can go a long way if enforced the right way by people who are in the business of providing works for the benefit of the differently abled, by preventing hold up, time delay, and so on, and giving them easy access to the work upon payment of royalty. You may recollect that I had earlier mentioned Articles 2 and 3 of the Appendix to the Berne Convention, which in turn respectively dealt with translation and reproduction licenses. These provisions, which India had been signatory to, are transported to our regime by way of section 32(1)(a) and 32(a). Translation licenses are provided for under 32(1)(a) and are available in respect of teaching, scholarship and research purposes and for literary or dramatic works in non-Indian languages. That is, the original work is in a non-Indian language. These licenses do not ensue in cases where the copyright owner has already authorized the circulation of copies of the translated work. The applicant also has to establish that he had requested and been denied authorization by the copyright owner to produce and publish such translation, or that he was unable to find the copyright owner despite the exercise of due diligence. It is only when these preconditions are satisfied and the board also feels that the applicant is competent to produce and publish a correct translation of the work and can provide payment of royalties for the copyright owner, that the board will permit the grant of such licenses. Similarly, reproduction licenses which are available for works that are not made at prices reasonable to the Indian market are availed for any literary, scientific or artistic works. Here the law makes a distinction between works that are used as part of systematic instructional activity and other works. So in the case of works that are used as part of systematic instructional activity, the copyright owner has a duty to ensure availability of these copies at prices reasonably comparable with that of similar works in India. The applicant only has to satisfy the board that he has requested and been denied authorization by the owner of the copyright, and that he is competent to reproduce and publish an accurate reproduction of the work and can pay royalties due to the copyright owner. Thus we see that the Indian law works in a very graded sort of way when it comes to enforcing compulsory licenses in respect of reproductions and translations, where the gradation is between the broad category of literary and musical works, and then from there proceeding to works which are used as part of instructional activity and works that are used for teaching, research and scholarship, and then works which are in languages that are not commonly used in a developed country. So in this very graded sort of way, the Indian law seeks to protect access to different works that are used by students and other entities in India. The last leg of our discussion today looks at one particular kind of compulsory licenses where there is no precondition of an application to be requested by an applicant for the grant of that particular compulsory license. On the other hand, the board itself fixes the rates of royalties on an ex ante basis in respect of all categories of works that qualify for the purposes of this provision. And as long as the royalties fixed by the board in respect of the broad category of that work is paid by the applicant, he can continue using that work, and all he needs to do is to intimate usage of that particular work through such license to the owner of the work. So this is broadly under the category of what one may call statutory licenses. Licenses where the rates of royalty are fixed in advance by the Copyright Board and as authorized by the statute. There are two broad cases or situations where these licenses can be granted. One is version recordings and the other is the grant of licenses for sound recordings for radio stations and other broadcasting organizations. So as we have already seen, in the case of the latter, that is the broadcasting organizations, there was already a provision in section 31, that is the compulsory license for works that were unreasonably withheld. Now the difference here and the difficulty earlier was that every radio broadcaster had to basically file an application for grant of such license. Now the present provision, that is section 31D, that has been introduced by virtue of the 2012 amendment, specifically mandates the fixation of royalties by the Copyright Board. And once the Copyright Board fixes these royalties, then there is no requirement of any application to be filed by each individual broadcaster. All that the broadcaster has to then do is to pay that certain royalty that has been fixed by the Copyright Board, and once he is willing to pay that and makes such payment to the owner of the copyright, he can continue using that particular work. Even with version recordings, in fact, this particular formula was already in place, but it was just that the provision was earlier found as part of the fair use enumerations in section 52. So with version recordings, the way it has worked till now, that is even prior to section 31C, which was introduced by way of the 2012 amendment, is that the version recordist has to inform the owner of copyright in the musical or literary work, as the case may be. He has to basically make it clear that he is desirous of making version recordings of that work, and he has to pay the royalties which have been fixed by the Copyright Board. So upon payment of such royalties, he can continue using it, and the permission is not an issue at all. Whether the copyright owner is reasonably agreeable, whether he disagrees with the rates fixed by the Copyright Board, whether any negotiation has to happen, none of this is at all an issue, because the way the statutory licenses work, they preclude any sort of negotiation. From the beginning, there is a certain rate that has been fixed by the board. You pay that certain rate, you go ahead and use that particular work. All you need to do is comply with the conditions of the license. So in the case of version recording, there are certain factors that there are certain conditions that have been imposed by the board, like for instance that you cannot misrepresent as though you are the original sound recording of that particular work. You are only a version recording, so you have to kind of not piggyback on an existing recording of the work. You cannot use, for instance, the photographs of the actors who acted in that particular film and so on and so forth. So you can't basically use the opportunity to piggyback. Second, you cannot of course make a cinematograph film based on the recording, because the version recording provision is only in respect of making sound recordings and not in respect of making a cinematograph film. So if you need to make a cinematograph film, then you need to take a separate license in respect of that particular underlying work. But as long as these conditions are satisfied, or you do not violate the terms of the license, you don't need to establish any unreasonable refusal on the part of the copyright owner, and the copyright owner's permission is not at all in question. So this provision is very controversial now in section 31D, because earlier under section 31, obviously the radio broadcaster or even the television broadcaster, though no such licenses were ever filed by television broadcasters, but all of them would have had to establish that there is an unreasonable refusal on the part of the copyright owner, and most times the unreasonable refusal would be due to seeking hefty payments of royalties. But now nothing of that sort. All you need to do is to first, get the copyright board to fix these royalties. Of course, while fixing the royalties, the copyright board does look into certain factors, such as there is a distinction in the rules between radio broadcasting and television broadcasting. The board can look into the peak hours when the work is being used on radio stations and the non-peak hours, and fix different royalties for the different times. For instance, even the owner of the work can go before the board and establish that there is considerable expenses, and to show that this is the capital investment involved in creating these works, and so on and so forth. So these various factors can be looked into by the board, but finally a blanket rate of royalty is fixed by the board, and all that the any broadcaster has to do is to pay that blanket rate of royalty and go ahead. So this is where the Indian law currently stands on compulsory licensing, and we need to see how the court applies these provisions. In fact, the constitutional validity of some of these provisions introduced in the 2012 amendment have been challenged, and they are currently pending before the courts. And we have to see whether these provisions stand constitutional scrutiny as well, because if the court takes a strict proprietarian dimension of copyright, then one could argue that this violates right to property, it also violates the right to carry on trade, and so on. But the whole idea behind these compulsory licenses is, as I mentioned in the beginning of the class, to bring in a kind of social dimension or social right angle to this idea of copyright as an exclusive monopoly, and bring in that variable and try and bring about some form of distributive justice, some form of access enhancement, and so on, through the use of these licenses. So I think with that, we can, keeping the thought in mind, we can look at how the court may possibly decide statutory licenses and their future in the Indian context as well. And with that, on that note, I think we can conclude this lecture. Thank you for your patient attendance.